All right, it's August 2022. All right, we have a good one for you. We have our speakers, Shem, Malachi Bay, and Michael Bay will be joining us shortly. All right. Today's topic is Moorish, the Moorish treaties, Moorish treaty protection and consular relations. Moorish treaty protection and consular relations, part 1. The speakers, once again, Shem, Malachi Bay and Michael Bay will be joining us shortly. All right. So Amanda, I'm gonna have on screen, Terrence. Right. We gotta bring it down.
Right. Is this up or down?
We gotta bring it down.
All right, here we go. How about that?
All right, there, yeah. All right, there we go.
Okay.
Amanda, you read for us under Article, second paragraph, under Article 6.
Under Article 6, Clause 2 of the Constitution, a treaty of the United States is a law of the land and a rule of decision in every state court. No state may interfere with the exercise of that power, nor may state hinder the fulfillment of a treaty's aims. United States v. Pink 315 U.S. 203, 1941. Belmont v. United States 301 U.S. 324, 1937, where a treaty regulates the choice of law for purposes of deciding specific questions. The choice of any other law by a state court is unconstitutional interference with treaty power. Hausenstein v. Lynham, 100 U.S. 483, 1879, construing Article 5 of this very treaty, where a treaty makes the decision of a foreign court decisive in certain matters. To ignore that decision is also to fly in the face of the supreme law of the land. Santo Vincenzo v. Egan, 284 U.S. 30, 1931.
All right, continue.
The Swiss United States Treaty of 1850 gives exclusive jurisdiction of the Swiss assets to the Swiss courts and makes Swiss law, as declared by Swiss judges, controlling in the disposition of this case. The Swiss law had already been definitively adjudicated prior to the 1958 decree of the surrogate here in issue. That decree was ignored, albeit innocently, by the surrogate, since it was not disclosed to him by the appellee here. And we would also suggest in passing that here is a situation where there is really a valid application of res judicata.
Schuylkill
Fuel Corporation versus Nyberg Realty Corporation, 250 New York, 304, 165, and E 456, 1929.
All right, so this is Hausenstein versus Lynham case. It's 1871, I believe. And what Hausenstein did, he changed his domicile, but not his domicile changed. All right. And he was never a resident of New York. His domicile changed. So he domiciled at New York. Was not a resident of New York. Hausenstein had purchased 3 properties. When Hausenstein transitioned, they had to be determined what Hausenstein's status was. The court had determined that Hausenstein had never renounced his allegiance and citizenship to Switzerland. And why that's important, because to decide what law applied, you can't decide what law applied until it's first determined what the status is. Does the Swiss treaty, the treaty between the Swiss Confederation and the United States 1850 applied to Haldenstein, or does the United States Constitution apply to Haldenstein? Does the United States Constitution and the state of New York Constitution apply to Haldenstein? Which one applied? So once it had been determined that Haldenstein was a citizen of Switzerland and had only domiciled in New York and had never renounced his allegiance to Switzerland. Now, his relatives were able to, the Article 5 of that 1850 treaty between the Swiss Confederation and the United States allow Haldenstein or any citizen of Switzerland domiciled in the United States, as well as a United States citizen domiciled in Switzerland. So that also applies to a United States citizen domiciled in Switzerland, a Switzerland citizen domiciled in the United States. All right? So it goes both ways. The Article 5 allows both citizens to recover proceeds from a sale of property. New York was imposing New York statute and ignored the treaty, ignored the 1850 treaty between the Swiss Confederation and United States. So this is where that Article 6 come into play. It comes into play, and when we read Haldenstein versus Lynham, we'll see what the Supreme Court writes about the supremacy clause. So I just want to set the stage for that. So we're gonna go right to paragraph 23 of Haldenstein versus Lynham. We'll start with paragraph 23. This is important because we can use this case. Moors can use this case. It's res judicata, already decided. All right, paragraph 23. Can we have another one? Who wants to read? Now we'll just have Amanda continue to read. Who wants to read? Who would like to read?
I'll continue.
All right.
The efficacy of the treaty is declared and guaranteed by the Constitution of the United States. That instrument took effect on the 4th day of March, 1789. In 1796, but a few years later, this court said, if doubts could exist before the adoption of the present national government, they must be entirely removed by the 6th article of the Constitution, which provides that all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. There can be no limitation on the power of the people of the United States. By their authority, the state constitutions were made, and by their authority, the Constitution of the United States was established. And they had the power to change or abolish the treaties made by or abolish the state constitutions, or to make them yield to the general government and to the treaties made by their authority. A treaty cannot be the supreme law of the land, that is, of all the United States, if any act of any state legislature can stand in its way. If the Constitution of the state, which is the fundamental law of the state and paramount to its legislature, must give way to a treaty and fall before it, can it be questioned whether the less power an act of the state legislature must not be prostrate? Is it declared will of the people of the United States that every treaty made by the authority of the United States shall be superior to the Constitution and laws of any individual state, and their will alone is to decide? If a law of a state contrary to a treaty is not void, but voidable only, by repeal or nullification by a state legislature, this certain consequence follows, that the will of a small part of the United States may control or defeat the will of the whole. Where v. Hilton, 3 Dallas 199.
All right. Shem, you want to elaborate on that?
Yes. Now, when you read, you hear about the will of the people. When the Lord Proprietors hired an esquire to write, that's what happened, how the Constitution got written. The same power on the colonies that Lord Proprietors designate who was the, now I say the will of the people, that's Congress. All the inherent powers in Congress. Me, the Constitution said, Congress have the inherent power. I mean, they got all the power. It's invested in the Congress. Once that National Congress make a decision on a matter, from a representative from every state is there, represent every state interest. Once they ratify something and consent to it, all the states are bound. Why? By the authorized representative who represents the state. Once he's signed, he's a part of Congress. So once you send a representative in Congress that make the Senate, the House of Representatives and the Senate, automatically the states become bound to that representative. So a treaty is an international contract between two belligerent powers. The great thing about this case that every Moorish should understand how he was able to make this claim. He made a claim as being a Swiss citizen, Swiss national. He never claimed to be a United States citizen. And the reason why he went to the courts, because the treaty does not stipulate that a council.
His relatives did. His relatives.
Yeah, it's relevant. See, a council in the treaty, there's no council. Where there's no council, the individual have a right to force that treaty under the United States law. If the treaty does not designate a council, then the parties that need. But if it designates a council, now I'm gonna tell you about the importance of a council. Is very important. All the nations decided, and Congress ratified the Convention of Consular Jurisdiction. That's very important. Now let me show you an example why some go wrong in international law. When an athlete in Russia got arrested, they had a Russian lawyer represent her, attorney. I have the Russian treaty. I look at that treaty with it stipulated. If it stipulated council, it was done wrong. But nationality is the main thing. The man claimed to be a Swiss citizen. If he claimed to be a Moor, like Abdullah said, we haven't educated. That's one thing. We come from behind. I can understand that. Now, the United States courts don't have jurisdiction over certain matters. The Congress set up an organization to hear all foreign treaties, certain treaties of councils. It got a council jurisdiction in that organization. The council got to get notice to the organization of a council, Moorish council. When a matter of dispute happens, you don't have to go to the courts. You go directly to the authority that's in the organization that's in authority designated by the United States. What happened is the organization steps in and allow the council to become an international judicial officer to hear the matter. See, the reason why Congress did that, because there's certain acts and declarations and treaties and agreements, executive orders that Congress and the president entered into, like a president entered executive order, and Congress will ratify that and consent to it. The courts can't hear that. Congress has set up an authority, the Justice Department, an organization, agency, that designate to hear that. They got power as if they were the federal court. The reason why we don't know, because we come from behind. To extensive research, listen to extensive research. I put this formula together and remedy to help our people. We got to get ourselves in government raised. The problem is now we got to get back in a mental capacity that we are people. We got to make a claim. It got to be a mental claim, recognition of ourselves as an inherent power. You're more. Or why you say you're more? You're Afro-American. You can't prove you're more. Okay, they can't prove they are either. But they're saying it, and it's a claim. What backs you up is coming from a government structure, a body of people coming together collectively having the self-determined. That self-determined right is in their head, their power, not yours, not a foreign nation. We got to stop being intimidated. We can't be intimidated. This is very important. We cannot be intimidated. If we get intimidated, they come in and subjugate us and take advantage of us. And by labeling us all these de facto names, and see what happened is they're allowing us to expatriate ourselves. What you mean expatriate? They're allowing you to not seek to change your status, your political status. When you walk to a Moor walk to the federal court and ask the judge to indicate something, the Moor is changing the political status. He said he's a Moor, but to the judge, he's not a Moor, because the judge looking at his political status. Only a citizen, the citizen resident of the state can come in this court and ask the court to speak. You ask the court to speak. That's a form of expatriation.
Let me clarify something, Shem. Let me clarify something real quick, because you said that. All right. Our people are Moors. So let's talk. Let me direct to conscious Moors. Conscious Moors. Those who know they're Moors, like ourselves and those who are on this class today. All right. We're talking about, we have the consanguinity. We are Moors by consanguinity. Now the question is, to what government to which you have allegiance. Saying you are Moor does not identify your political allegiance. Hear me out.
Absolutely, that's right.
This has to be clarified. Well, this is because there's been misconceptions upon misconceptions upon misconceptions. This claim of nationalization paperwork that claiming that saying you're Moor does what? We are Moors. That means, all right, those who do not come out, those who do not claim to be Moors, they're still Moors. I mean, someone saying that they're Moor doesn't make them a Moor. You were already that before you knew it. You were born Moor.
Absolutely.
You were Moor before you knew you were Moor. So what is the issue here? Is that our empire has been collapsed. So yes, we are claiming to be Moors, but we're claiming those who have a body of Moors who are claiming the Constitution as their own, the United States Constitution. Yet they're claiming to be Moors. So what Shem is talking about is the political status. You have the consanguinity status, the ancestry, lineage, descent, bloodline, pedigree. That's your Moor. What is your political status? Saying you're Moor doesn't identify your political status. All right, for instance, I'm a Moor. I renounce my allegiance to my mother, Morocco. I renounce my allegiance. I'm going to change my political status. I can't change my nationality. I can't change my bloodline, my consanguinity, my ancestry, my descent, my national origin. That can never change. However, my political status can change. I can renounce my allegiance to my mother, Morocco, and declare allegiance to China by going through the naturalization process of China. All right? In my house, I have the Moorish flag and the Chinese flag. Now, I only have the Moorish flag in my house because of, culture. That is the flag of my national origin. But that's not the flag that I'm protected under right now. So I have the Moorish flag and the Chinese flag. I'm protected under the Chinese flag. I'm not protected. I was once protected under the Moorish flag. All right. I just have it in my house because that's the flag of my national origin. But my political status is that I'm a Chinese citizen and I'm now protected under the Chinese flag. So this is a change of political status, but not nationality, ancestry, descent. Our issue is that
You went on mute, Abdullah. Unmute you. Hold on.
You're mute, Azul.
What happened here?
You're mute.
Has collapsed the Moroccan Empire over the period of time due to war and conquest. Her children, us, have been placed under subjugation. We're in the hands of the extent of the child of Great Britain. That child of Great Britain, the United States. The child of Great Britain, the United States, enacted the 14th Amendment in 1868. All persons born or naturalized in the United States are subjected to the jurisdictions thereof and residents of the states therein. All right, so there are state birth certificates, New Jersey, South Carolina, North Carolina, etc. All right, that's subjugation. That is not an act of post-millennium. Now we're talking international law. Post-millennium, under war. In international law, we have peace and war. Under war in international law is the category post-millennium. That means that deals with recovery. I mean, reclaim the position that you were in before conquest. Before conquest. As if you had not been conquered, as far as restoring the sovereign power, finance, and government structure, and military, and everything. That's post-millennium. The 14th Amendment, it's not post-millennium. That's an act of subjugation. For instance, let me continue. I come to your house. I take over your house for 10 years. You're still in the house, but I'm taking over your house. And I say, well, you know, then 10 years later, I say, you know what? I'm gonna allow you to you weren't allowed to go upstairs. Now I'm gonna write that you can go upstairs now. I'm gonna now write that you don't need my permission to go in the refrigerator. He said, oh man, I like Abdullah. Man, I like Abdullah, man. Man, Abdullah he's giving us, you dummy, I'm in your house. What do you mean you like Abdullah? What do you mean you like Abdullah? What are you talking about? That's not post-millennium. Post-millennium means I leave your house. Post-millennium is I leave your house. That's post-millennium. I leave your house, but before I leave your house, I put about $5 million in your bank account. Remember, it's been 10 years. So I put $5 million in your bank account. It's about post-millennium. So I put about $5 million in your bank account. All right? Upgrade the house and everything. I mean, position to where you were before I took over. 14 members not minimum. The problem is that we don't know international law. We do not study international law and treaty. That's why we're having these classes. That's why we've had classes on the Academy of Providence. That's why we're doing what we're doing. We must study international law. We're gonna, hopefully we can read later. I'll read later on. We'll have someone read later on. I text out my the book summary for Moors and Masonry Part 2. So I want somebody to read the book summary for Moors and Masonry Part 2 later on. All right. So I texted out about the 20. I think Kawaza, you have it. The book summary for Moors and Masonry Part 2. All right. So we must understand international law. I learned the term post-millennium is in the category of international law under war. Because that's dealing with the settlement, the restoration process. All right. So I just wanted to provide clarity on political status change as Shem is talking about. All right, go ahead, Shem. So we want to go, tell you what, can we go to the first question?
Yes.
We go to the first question?
Yes. Can we,
I have the questions here. You want to put the questions up, but I do have the questions written out, Terrence.
okay, so here, I just want to display this since you were talking about post-millennium.
All right, so question number 1, Shem.
Abdullah,
Is Michael on? Is Michael on?
Abdullah, can you hear me?
Is Michael with us? Michael. All right, Michael's with us.
Peace,
All right,
peace, I'm
good.
here.
So Michael and Shem,
Abdullah, can you hear me?
Michael and Shem,
Can I be
Yeah.
heard?
does a national or a foreign nation
Hello?
in treaty with the United States enforce the United States Constitution and United States titles and codes, or the treaty between his or her nation and the United States? Let me reread the question. Does a national or a foreign nation in treaty with the United States enforce the United States Constitution and United States titles and codes, or the treaty, or enforce the treaty between his or her nation with the United States?
If the foreign national, if he's a Moor, he has the council enforce the treaty. If it's executed in the rules of the treaty,
Is it
then
me?
a council is the officer that's supposed to be the one hearing the matter. Then it got to be the treaty, because once the treaty stipulates that and Congress consent to, and the president sign it, that puts a burden on Congress now to pass legislation that makes sure that treaty become a law throughout the whole state if it's not executed. But if it's executed, if it's self-determined among itself, no legislative act, that means they also come enforce it just by on the council's jurisdiction. The council enforces that treaty. The Constitution does not give a more any rights to the amendments. The treaty gives a more or the national all the rights, and the treaty is the body of the treaty, the agreement. Because you gotta understand, see, what the misperception was, and I believe this too, years ago, we the people. Ask yourself a question: who's we the people? Escort to write a new contract for the state. Who's we the people of the United States? Who's that?
Hold on, Shem. Did you hear my question?
Yeah.
Did you hear the Shem?
I said treaty. I broke down treaty.
No, Shem. Did you hear the question?
Yes.
Because what was I didn't, it was because I couldn't hear you. I had to go out and come back in, so I apologize. So I didn't think you had heard my question. All right, good.
The treaty.
All right.
So the treaty, self-determined treaty speaks for itself. What I was saying was that for a lot of years we were taught that Moors are part and parcel to the Constitution. I used to believe that, and what they used to use is we the people. Now you got to ask your simple question: who's we the people? And the Constitution, that's the law of proprietors. How you know, Shem? Because under the colony charters, they're the only ones given a charter by the kings and princes and queens. On the colony charter, the law of proprietors was the one elected the Congress, and it became the governors themselves and elected the judges. So the same power the law of proprietors had, they get the same inherent power from Congress. Congress got the inherent power. So when Congress give their consent to a ratification of a treaty after the president signed it, that becomes the law of the land of all the states, because all the inherent powers in Congress. So the treaty is which you should enforce, because it got the signature approval of all the representatives of all the states, all are legally binding now. But the instrument become political. Once the nation signed it, it become political to all the states. So the treaty, as you can see in the United States Supreme Court case, in the Switzerland case, they refer to the treaty. They refer to the federal rules, no statutes. They ignore any code of the state, legislative act. They ain't say no code, statute, or Congress. They refer to the language of the treaty. In that case, that's called res judicata. That's called a judicial notice. What is a judicial notice? You let every court know when that treaty go in front of them, that is the law to follow. That's why the judicial notice given by the Attorney General office. When they come into a state matter, a local county, they get judicial notice, which means the powers that what they're going by, what's the higher authority here. So a treaty is the only thing that a foreign national can rely on if the treaty is self-determinated, is treaty is self-executed, and a language read that a council. Let me give you an example. When a man get locked up, he claims to be a resident citizen of the state or United States citizen. The first thing he do when he get locked up, the United States Supreme Court said that citizen got a right to counsel under the Sixth Amendment. Now, why they use the Constitution for one day their subjects? Same way they use the Constitution for their subjects, we gotta use the Constitution, we gotta use the treaty for ourselves, Moors. Because if you are not a resident alien, if you're not a resident, I mean, if you come to immigration and you're a citizen resident and you're not a legal alien of a foreign nation making that claim, then the Constitution apply to you. That's why I read your Sixth Amendment right before they ask you questions. So you got a right to remain silent, and then you say you're held against the court of law. You have a right to an attorney. You have a right to a counsel. So why are they telling you that? That's the Sixth Amendment. They're assuming automatically that you're a United States citizen. So they read you the instrument, the agreement that protects you. They court say that. They court. So just like two belligerent powers sign a treaty, they stipulate in that treaty how that national represented in that foreign territory. Political power, foreign jurisdictions, territory power. Like Abdullah said a long time ago, if I go inside Walmart or I go inside a hospital, I'm going inside United States territory. Why, Shem? Because that organization either licensed by the state or the United States. So therefore, that territory I'm going in, I become an alien. I'm not a citizen or resident or immigration status. Therefore, I'm protected by treaty. So just like a man or woman that's not a conscious Moor, that don't know, they take it as United States citizen, they have a right to say, well, I got a Fourth Amendment right. They don't know, they're unconscious. They're political allegiance to that government. That's all they know. But a conscious Moor supposed to always say, I got a right to counsel. I want my right to counsel. That's protected by treaty. It's also protected by an international convention that the United States President signed and Congress ratified, British ratified, Great Britain, France ratified, Spain ratified, all the sovereign conquest powers, principles ratify that. And they agreed that every foreign national alien got a right to counsel. I want my right to counsel. What happens is now the police, the state, all the courts, all the state, federal court lose jurisdiction. Once the counsel is notified to the United States Foreign Affairs and that's the Department of Foreign Affairs, the council jurisdiction comes in there. Council is the only judicial officer that can rule that case. So they pass it called letter rogatory and they hand over witnesses, transcripts. They got to be heard before the council. The council becomes the judge in the matter. He sends us a stenographer to take notes, everything. See, we come from behind. We just learned this. And we can educate ourselves. We come from behind. Now we're being educated, true government, and we're in government array and government structure coming together as a population, having votes. We can, in government array, we can protect ourselves. Man. What I mean is that we can enforce these treaties because we claim to be a county or a state inside Morocco territory, empire territory. Anybody got any other questions?
We do have one hand up, Marcus L. I tried to get him in before, I guess Abdullah couldn't hear us at the time. So go ahead.
Okay, go ahead, brother Marcus L. Marcus?
Can you hear me?
Yeah, thank you, Marcus.
Yeah, I got a question on behalf of that letter of rogatory, as well as other international law bases. Just a second here. Just a second.
Say it again. Marcus, say that again.
I got a question on behalf of that letter of rogatory. So I've been studying with good brothers from ANPAC, and they have stated several times as to what the Yes, sir.
Well, I can't,
That's
brother.
the
You've got too much no static in your mic.
Can you hear me now?
Yeah,
Yes.
Much better.
Okay.
Much better.
On behalf of that letter of rogatory, I've been studying the good brothers from AMPEC, and they have laid out in international law what exactly requires and how it matches with our own Moroccan treaties. So it's nothing new. But as far as the letter of rogatory in specific, being that it gets sent to a court that's not the international, the ICJ, is that would that be, being that AMPAC has basically laid out the steps as far as sign the Constitution, get the seal, the inauguration, et cetera, in which requires both in Moroccan law and modern international law. What standpoint or what value, what weight does the letter of rogatory have in regards to international law? And the other half of that question is, on behalf of AMPAC, would you consider those steps unlawful or out of international law?
Okay, Marvin, let me split in a letter of rogatory. It's for assistance. It is international judicial assistance. When a council files a letter of rogatory to any court, let me explain. You gotta understand procedure. In the federal court, yes, the federal courts have a magistrate judge set up. Now, you file it internationally, that means you're going before the world court, accusing a treaty nation of crimes against humanity and violation of the treaty. You're trying to force the treaty. One is an international court, one is a local court. That country or that state is in violation. So what the council do is that he goes to that court, and the courts have set up an international magistrate, a magistrate deal with international affairs. He issued a case number, so it goes in the hands of the Department of International Affairs. The letter of rogatory removes it, and the Department of International Affairs that deal with treaty affairs for the United States will hear that.
Shem, hold on. Shem, Office of International Affairs and the United States Justice Department.
Yes,
the
yes.
Office of International Affairs and United States Justice Department. The department is the Justice Department. The office is Office of International Affairs.
Absolutely. That's right, Abdul. Thank you. It's the Office of International Affairs. It gets transferred to them. They got an organization, the Justice Department, that's been set up and put in power by Congress to hear all foreign matters, foreign disputes with treaties, conventions, and declarations signed by the United States President and ratified by Congress, considered by Congress. So therefore, we're not dealing with a world court matter, The Hague. The Hague matter is when you file a complaint with the World Court as a sovereign body and say that you a party that's injured based on a contracting party. And the Hague got power here. The International Court of Arbitration under the Hague will hear the matter because it become an arbitration matter. Now, one dealing with directly with the court. See what's going on, Marcus. A lot of us have been educated that in the United States, there's an international office of international affairs in the Justice Department. They got all the authority, Marcus, over the federal courts to hear all matters. Their job is to bring the council jurisdiction and to power. I mean, they take over. They say the council got jurisdiction based on the treaty. They allow the council to work through them to grab information, evidence, witnesses, testimony, everything, screen witnesses. It's a council jurisdiction. Every council got to file a notice to let them know their part that they got a Moorish government here or any government here represent that nation. Now, dealing with the Hague is a different matter. Letters of rogatory only asking a court or the international office to assist them in a judicial matter based on the agreement they got with that country. That's all it means. In that judicial assistance. You got it, Marcus?
Yeah, so the other question, the other side of that question. So would that consider the teachings from ANPAC unlawful, would you say, as far as going to the United Nations, going
Mark,
to, you know, sending in, putting them on notice, basically, even though
Mark,
you ain't got to be a member?
when you go to the United Nations, number one, Marcus, you gotta be registered in that society, organization of the UN. Number one, that's number one. You gotta be registered. Either you will be registered as a non-government organization, or you registered as an old state, make it independent as a new state and an old state that already recognized under international law. Now, when you go to the United Nations, Hague, Department of Hague, that means you're a party to you ratify the UN Constitution. See, every nation got to ratify the UN Charter to become a member. Yes, you got to ratify it. And when you ratify it, you got to reserve your rights in your own national constitution. See, so you got rights, you got to reserve, keep them reserved. Now, when you do that, now you can file a complaint with a letter of obligatory to the World Court, because you make it a government dispute. The government is now protecting its people by saying, hey, listen, we got another government here that signed an agreement with our government about, let's say 100 years ago. They're not honoring the contract. Or they signed to the convention or this declaration. The government ratified, the president signed it. It's binding on them. They signed the Constitution of the UN. They signed the Human Rights Bill, the Declaration of the Human Rights, the Bill of Rights to protect all humans. They signed that. United States Congress signed that and ratified. So yes, if you're a Moorish government, you go directly to the World Court. You go to the United States court, or that government court to try to force that. You go to the World Court because all y'all are party to that. They ratified that Constitution. They said they ratified because Congress sent and the president signed it. So they're legally obligated to it. So you take the matter for the World Court, letter of obligatory, so you can win. I can't lose because I know they're gonna force this world agreement. Now that's on the international level. Now on a local level, the council removes it out of that jurisdiction to the council court, to the Office of International Affairs of the Justice Department. That's why he tests the letter of obligatory, because that's the Office of International Affairs. That means the United States set an agency to hear all international disputes with treaty powers in Morocco. That's their job. They got a council jurisdiction. Their job is to force treaties. That's it.
Excuse me, this is Abdul-Hakim. Is that the Department of Justice?
Yes. Inside the Justice Department, State Department, inside the Justice Department, they got an international organization. They don't see this happen. People, jurists from France, Great Britain, China, they know about this. They let them talk on the media, right? They don't care, because this is not gonna be put out there for everybody to learn. The Abdullah, right? They teach this to certain worthy men. They train them. They train them, exercise this power by training them, educating them. You got right down there, you got international esquires that represent the American Bar Association, International Bar Association, that represent all treaty matters. Yes, they know, they talk about it, listen to them. They talk about it, that the treaty is the only thing that can be litigated, the treaty. So you got the World Court dealing with, you bring a claim against somebody that's not complying, they're signing to a convention or declaration of the UN. Oh, what you mean? I'm gonna tell you, the UN is a world congress. All nations and states send an ambassador. The ambassador is the international representative of that nation. Once that nation ratified that charter, they're legally bound to that charter, to obey that charter, to force that charter in their jurisdiction. This is why Congress passed that, created the act, and get an Office of International Affairs in the State Department and placed in the Justice Department, because they're supposed to work with the Justice Department, and the Justice Department is supposed to work with us through treaty. The problem is we haven't got a house order, we haven't been educated, and we're not addressing government array. We don't have a population. If a man make a claim to be more constantly, he's there by consequently. First of all, he's there by consequently. What happened is, if a Moor make that claim constantly, he got to remember, he didn't come into immigration. Nobody came into the Immigration Act. What happened is, when Lincoln got assassinated, Congress passed the Expatriation Act. Look it up. So we got to be educated. It's called a voluntary consent to actually express contract. Moors are going into the courtroom expressing a contract to verbally. By doing that, they expatriate themselves out of their own government political status. They're not changing their moral status. They're changing their political status. They're no longer doing it to the council. They're doing it to a foreign judicial officer, an officer that's not even in the treaty. There's no mention of a judge, federal judge, or United States judge in the treaty. To hear that matter, it's a council. So when you go into the courts talking to a judge, you expatriate yourself out of your own country politically. You change your political status. Yeah, you say, I'm more and more. You say country all day long. But I'm talking about your actions, your performance. That's called a performance contract. To that contract, you expatriate yourself out there. Anything else, Marcus?
Brother, brother, that was excellent, brother. Excellent. Oh my goodness. We have a hand. Well, we know Akeem, did you answer the question? Who else says that? No other hand? We have Akeem. We have Akeem.
Yes.
Hey,
Yes,
hey, Vincent, how you doing?
Hey, brother, good to hear you still in good spirits and moving on in this work, man.
Yes, sir. Yes, sir.
Very strong, man.
Yes, sir.
Mm-hmm. No doubt, I'm still in. I'm still down.
I want Kim to do it.
Okay, I have a question for clarification. The term "Moor" in the political arena. I'm looking at Moor as a general term because we have, it seems through my studies, we have Moors on all sides. We have Moors of Morocco, Moors from the European treaty nations, and also the Moors of the United States. So saying Moor is a general term, so I would ask to speak to Moors specifically under which flag and political association. We learned that, yeah, we got Moors on each side. Moors that are sent from Europe and now are here on our side.
I'm going to answer that. Let me answer that. I'm going to answer that. In the 1736 treaty, 1736 treaty between Morocco and Great Britain, I believe it's Article 4 in the 1736 treaty. It makes reference to, on both Morocco and Great Britain, any more subject people inhabited in any Moorish territory or dominion, as well as on Great Britain's side. So you gotta keep in mind that the Moroccan Empire is a vast empire, right? So that's all right. We can't just focus, we can't just limit ourselves to today. That is actually, we can't limit ourselves just today. Why did I reference a treaty of 1736? 1736 treaty, because I'm not making stuff up. I don't make stuff up. That's why I'm referencing things. It talks about, and this treaties be during the 1600s as well, willing to any more subject people, inhabitants in any dominion of the Moroccan Empire territory, and also stand for Great Britain. So that keep in mind. So you said Moor first. Moor is not a term. Moor is not a term. Moor is a word, and the category that word fits in, it's a nationality of a people. It's a pedigree, national origin, descent, parentage, lineage, ancestry, national origin of a people who've been placed under subjugation for several generations by Spain, Portugal, France, England/Great Britain, her child, United States, and the Netherlands, as well as the Dutch Republic. They collapsed due to series of wars going back to going back to 1095, starting with the Crusades against the Moors. So throughout the 1100s, 1200s, 1300s, 1400s, 1500s, 1600s, we're talking about a series of wars, battles on seas, as well as land. So there was been a gradual, over a period of centuries, a gradual loss of power that includes the Ottoman Empire. Let me finish, brother, please. Let me finish.
Flag versus flag.
In the 1686 treaty between Algiers and Great Britain, Article 4 of that treaty references Turks and Moors. So Moors and Article 4 of that treaty between Algiers and Great Britain are also protected by that treaty. So I'm referencing these treaties because you learn a lot. You'll learn a lot of history through treaty study. History and jurisprudence through treaty study. When you're not making stuff up, you can reference the treaty after treaty after treaty after treaty after treaty. 300, 400 years of treaty. And we just it's through a lack of study. That's all. This is why I have more information 1 and more information part 2. Through a lack of study, so you can have the information at your fingertips. We have another question. As well as the 1856 treaty. Let me talk about the 1856 treaty. 1856, the general treaty. The 1856 General Treaty between Morocco and Great Britain. That is a very comprehensive treaty. And in that treaty, the Moorish government has exclusive jurisdiction when it comes to case issues, matters regarding Moors in Great Britain's jurisdiction. It's the Moorish government. And then we also reference a sheikh and pasha. So these, you learn a lot of jurisprudence through treaty study. In the, let me give reference to jurisprudence through treaty study. In the 1952 case between France and the United States, you have the summary of the case, which is about 30, 40 pages. That's the case summary. But the case embodies memorials and counter memorials and other motion pleadings. That's the case. So if you read the 20, 30, that's not the case. So don't call that the case. That's the case summary. The case is actually the instruments. The France initiated the case by drafting and filing what's called a memorial. In international law, a motion that starts a case is called a memorial. United States has 6 months to respond. It's called a counter memorial in international law. United States drafted, the United States jurists drafted, and it's that counter memorial is 600 pages long. The United States counter memorial to France's memorial in that 1952 case is 600 pages long. 30 pages of that 600 pages is in chapter 8, chapter 9, chapter 10. Chapter 10 of Moorish Masonry Part 2. I took 30 pages out. Chapter 10 of Moorish Masonry Part 2. What I did was that the jurists for the United States referenced several treaty clauses, extraterritorial, what they call compensatory. It was called compensatory. Now it's called extraterritorial consular jurisdiction. And they referenced several extraterritorial compensatory clauses dealing with treaties dating back to the 1600s. Those in them, that's in Moorish Masonry Part 2, Chapter 10. It's very comprehensive. In fact, I sent that to Terrence 2 years ago. I gave that to Terrence 2 years ago. I sent that to several people too. I came across that 2 years ago. I didn't understand it then. Of course, I understand it now. All right, so I understand it now, and I want to thank Shem Malachi Bey. Shem Malachi Bey is the reason that I understand it. Right? So he's on fire today. Michael, you have any comment? You want to?
Nah, no, I mean, I'm just listening to you and Brother Shem.
Hey,
Do you
Michael,
have anything
Michael,
you want
talk
to
about your
expound on?
experience. Michael, talk about your case. Talk about your case. Talk about your case.
Oh, well, the cases that I've the cases that my society has fought. We exercise the treaty.
Mute your mic, please. Mute your mics, please. Mute your mic, please. Thank you.
Yeah, we pretty much used the treaty, 1856 treaty, because that is the superior treaty for Moroccan nationals, and utilizing that treaty has got us victory in a couple of civil cases and a criminal case, and we were just able to remove it pursuant to the treaty provisions, and that's so yeah. So this stuff is really when you come in your proper array. And
excuse me, can y'all hear him? Hold on, Michael. Can y'all hear him?
Yes, I can.
Yeah.
You do? So it's on my end then. All right, no,
No,
y'all
there's
can
a
hear.
little bit of background noise.
Well, that's
okay.
what.
Yeah. Right. Okay. Yeah. Okay. So so everything that Professor and saying Brother Shem is explaining to you, the importance of the treaties, and that's our protection. We don't have any other protection, but that protection that we are certain is supreme protection, as Professor Abdullah alluded to, res judicata, which means that it's saying it's already been saying well settled. So in the courts of law, these case laws are already saying going and showing how the treaties act as both active legislation and federal law. So pretty much anytime a state brings a case under their laws, their statutes, even a state constitution. A state constitution is the highest law in each state. So you have the state constitution first, then you got the state statutes and codes and bylaws of each state. But all those bylaws, codes, and even a state constitution has to bow down whenever a treaty comes into contact with it. So whenever they come into a conflict, the court has already been established that the court has to rule based on the provisions of the treaty. So everything else gets overruled. So yeah, so that's pretty much
Michael,
it. So
go into your case. Go into the case, Michael.
Well, there was this really, in a nutshell, and this is actually saying probably better than not. Once I asserted the treaties and my protection for my national, there was nothing to talk about. There was no conflict. There was no comeback. There was no contact. There was no order. There was no dismissals with prejudice. It was just, we don't have jurisdiction. Actually, one of the cases, I had a civil matter. One of my nationals who was driving without a license in New Jersey, and I pretty much appeared on behalf of my national as counsel. And long story short, it was through a Zoom. We had a Zoom meeting because obviously it was out of state. It was just too inconvenient. Wasn't having to do that. So I registered to go pretty much attend virtually through their Zoom. And I just came in. I was in attendance as a consul, which I was appointed through my state. And I was on pretty much the panel with a whole bunch of other barristers, esquires, obviously. Difference, counsel, for the record, and let the record reflect. Counsel is dealing with the United States esquires. They are British subjects by default because they are under esquire titles. Now we as consul, whatever the word consul is brought up, okay, consul, 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 vice consul, consul general. Whenever consul is being brought up, automatically equate that to international law via treaty. International law via treaty. A consul will only ever at all times come on behalf okay, in any type of matter based on a treaty, whereas a council will only come based on their barrister. They are subjects. They are bound to the United States Constitution. They are bound to the state's bylaws and statutory codes that each state, represents and invokes. But a consul has a superior claim and a superior stance in terms of status because it's an international one. And when a consul comes in on behalf of its national dealing with a state conflict, when that treaty gets now entered into, as you all know, this is important too. Whenever, it doesn't matter where you're at, as long as you're in the 50 states of the Union, you can enforce a treaty as long as the United States is a signer on and ratified that treaty because all states are subjected to that treaty, to the treaty and its provisions, because can't no state make a treaty. It's already being established even in their constitution. I believe it's Article 1, Section 10. No state can enter into any treaty or alliance, but only the United States can do that. So with that said, I had spoke to the prosecutor and told the prosecutor directly. I said, all I had to say was, I had paperwork in advance that I had sent to pretty much, I had a case built up in advance. But once I did that, I just had to
paperwork, Michael. What is that paperwork, Michael?
Oh, the paperwork I did in this particular. Oh, it was what I did was I just did a letter of rogatory, and pretty much just saying asserted the status and pretty much gave my information for my state where I could be contacted, where I could be located, and also the provisions for protection. It's a letter of rogatory. That's how you do it.
Michael, try to be as specific as you can. Try to be as specific as you can, because this is a class. All right.
Yeah, that's what
you got the floor, brother. The floor is yours, brother.
Right. Because of the setting, because it was a setting where it was virtual, I was virtually in attendance as opposed to physically in attendance. What I did was I wanted to just be prudent. So I wanted to pretty much give them an advance notice. So like 2-3 days before I had to show up I had to appear on behalf of my national. I sent paperwork in. So when I sent the paperwork in, I sent it, attention to the executive director, saying of the traffic agency, as well as to whatever judicial officer that was going to be over, administrative officer, the administrative officers, whatever administrative officer, i.e. judge, the attention to the clerk, as well as to, I sent it to the judge, the clerk, and the executive director of the agency, right? So I sent it out. So now I didn't get no response, but I didn't care just as long as I had confirmation that I sent it. I didn't want to send it via mail because even though you send a correspondence via mail, you can send it certified, registered mail, etc., and or you can get proof that they received it, but you don't necessarily know if they're going to open up the package, nor if they necessarily in the office. These people are busy. They run in commerce 24/7. So they don't always get to their mail, saying right away. But when you send a fax, remember that's expedited because it's faxed right over to the main office. So, they get faxes every day. And usually when something is faxed, it's urgent because it's a fax, it's faxed over. So when I sent it over, I didn't get no response to it. So I called like the day before the appearance had actually done it. I spoke to one of the reps within the agency that worked under the clerk, and I just wanted to confirm that they got the fax, and she confirmed that she got the fax. So I said, okay, well, cool. Well, since you got the fax, I'm the consul so and so that sent that fax. Blah blah blah. This is the state you represent. My website. My saying this is my contact number. This is my state email. Blah blah blah. If you need any more information, just let me know. So she pretty much put me on hold. She came back. She's like, well, no, there's nothing really to talk about. So I guess just the thing to do is just to come tomorrow because your national is scheduled to be an appearance via Zoom. So just come tomorrow, right? So I said, okay. Well, my defendant's not coming. He's a non-U.S. citizen, so therefore, he cannot, be in attendance. We cannot discuss the merits nor go into subject matter. The treaty provision does not permit that. So she said, okay, well, then I guess you'll be in attendance for that. I said, yes, I will. So, and the court date was for 9 o'clock in the morning the next day. So I entered via Zoom from my place. I pretty much just went online and just got in. When I got in there, she was directing current, telling everyone to go there, go here, blah, blah, blah. This person, I see the judge, you call each person by their name to make sure he's in attendance. So I'm sitting there with a bunch, I'm the consul, the only consul. I'm in attendance with a bunch of barristers and esquires defending their, saying their clients. So by the time she got to me, she's like, okay, Anthony Harris. So I just said, oh, I'm the consul, I'm the consul general and minister for foreign affairs regarding that defendant, Anthony so and so. So and they well, okay, so you're the consul. So what are you saying? I said to her that my he's a non-US citizen, foreign national, and I sent paperwork in. I had confirmation from one of your secretaries, the name so and so, and she confirmed that you received the correspondence. So I'm pretty much just here on the behalf, as the treaty does not not allow my client, my national, to be in attendance. It actually is going to be a conflict of interest as it violates the provisions of the treaty. Once I told her that, she said to me verbatim, she said, "Are you telling me that you're saying that your national can't be issued these tickets?" I said, "Prosecutor, absolutely correct. He cannot be issued these tickets." She said, "Okay, no problem. I'm going to move this over to the judge overseeing the matters, and I'm going to put this in for full dismissal. So please just give me a minute, Mr. Consul. I'm going to send you over to the other room. So please just wait a few minutes. Even though I'm going to go for dismissal, can you just please wait a few extra minutes just in case the judge has any questions or inquiries for you?" No problem. When the judge got to me, finally, when the judge got up to me and asked for my national, I came in on this behalf against consul, whatever. First thing the judge said, "What are we doing again with this case?" The prosecutor responded, "Oh, we're going for dismissal." Okay, case dismissed. Have a good day.
That's why I wanted you to be as specific as possible, because this people are learning. The general,
Let me explain why they dismissed it. And let me explain why Michael followed the full man. Let me explain why they dismissed it. First of all, they dismissed it because the judge didn't have jurisdiction to speak over the Moor. He didn't have jurisdiction over the body, the substance, the vessel. The treaty said consul. So if they didn't want to deliver it over to the consul jurisdiction, so they didn't want to wake everybody up. So what they did was they just dismissed it. But the main thing is, he had consular protection. Consul was there under the World Convention, under treaty provision. He didn't witness speaking for himself, saying, "Well, I'm a Moor, and you can't trial me. I could do this and that." It was no argument because the counsel say, "I have a right to hear the matter," and therefore the judge don't have jurisdiction, which means control over the vessel, the body of the Moor. To have control. The council has that authority. So it's very important. While council, just like the Supreme Court said they got a right, a United States citizen got a right to counsel, you got a right to your counsel on a treaty. A lot of Moors don't give their counselor representative because we're not set right. We're not set a government right. We have a government political structure set up. Thank you, Michael.
Yeah, you're welcome. And that was just that was the only experience that I had where I actually went in face to face and addressed, saying the officials, of the court, regarding any particular matter. I had other cases too where I got big through. I didn't have to do none of that. I just sent the paperwork in and they knew what time it was based on the treaty. So once I sent the treaty in, attached letter of rogatory, saying what, maybe affidavit, verify, complaint, attached to it. And then pretty much just, because what it is that when you're dealing with a treaty and you're dealing with the United States court, remember the treaty itself, whatever international law in the United States, it doesn't allow you to go into the merits and subject matter of the matter. So the treaty doesn't allow that. So I don't go into any merits of subject matter. I pretty much navigate the court based on what the treaty says. So it's baby. You see what people need to understand in the courtroom. The judges. Remember the judges. He's running a business. He's running a bank. He's running the bank. He or she is running the bank. So what it is when they're running the bank, you have to figure out, how to navigate through the bank. So just like she's a judge or he's a judge, he or she is a judge overseeing the ship. They're overseeing the ships and commerce. Remember, they're running Admiralty Maritime law in the courtrooms. So they're controlling the electrical conductors in the courtroom, controlling traffic, commerce and traffic. So I got a treaty that trumps anything that she's running in the courtroom. So I'm gonna just say, listen, I'm navigating the ship here, and now this is what it is. This is what it says. Now either you're gonna do that or you're gonna commit an act of war and therefore lose everything, get locked up, and/or both. So he or she gonna do is just say, he or she is gonna have to capitulate because you hit her with it. As the saying goes, I basically wrote a check that I asked for in cash.
Now, Michael has these problems. He consulted me and he had a problem with a criminal matter. And I told Michael, I said, Michael, you got to do a letter about. Michael said, well, I did it. They didn't give me a case now. I said, no, it got to go before a special magistrate. They were international affairs. The magistrate is appointed by the Justice Department and Congress, the State Department, to give case numbers to all international affairs. And when he did letter rogatory, Michael followed my instructions, what he should do. He put me out as a counsel. I said, go ahead and remove a petition and notice to remove it. Test the letter rogatory for a special magistrate. And what happened, Mike? A day later, the magistrate called you, gave you a case number, right?
Oh yeah. That was the matter of fact. They gave us the case number right away. Yeah. What it was, the inconvenience was in that matter was only because they had the COVID lockdown in that particular state. For my national, they had the COVID lockdown, so I couldn't go in there and file the right way. So I had to put it in a drop desk at the main office. So I had to just keep following up within a day or two. And then once within a day or two, they got it. They gave us a case number. But if I was able to walk in like I did in my other cases, I would have been able to just file with the clerk of the court and I would have got that file number right away, the case number right away. It was just due to
this is very important. When Mike filed that, right? Mike followed my instructions. I said, Mike, do a notice of removal and notice and petition to move from their court to the council court, the move deed under 1856 treaty on a council jurisdiction. When he did that, the federal judge closed the case when he moved it. I looked it up, a jurist, a legalized jurist, they didn't have to say, anytime a court close the case, not dismiss it, close it. The parties that cannot go for a remand back to that jurisdiction. So he won. So council jurisdiction means a lot. The judge closed it because the judge couldn't hear it himself, neither could the state court hear it. That's why the judge closed the matter. Finished. It's over. Because
right.
The treaty said his court.
Right.
He said it's removed out of his court. They no longer have jurisdiction. The case goes down to the Moorish court based on the Granada Treaty and the 1856 Treaty between Great Britain and Morocco. And the Granada Treaty, the Moorish government keep their land, their political rights, and their jurisdiction on all the civil and criminal matters, period. In the British domain and in the Moorish domain, territory domain. The Moor, when it's dealing with a Moor, it's been a British territory, which the United States, a council got to hear it.
And that's right. And that's why they doing everything in their willpower. This is why the European powers are doing everything in their willpower to keep the Moors in subjugation. That's okay. So everybody knows it's not a civil rights matter. It's not a racism, issue, saying more than it is an industry and basically a land rights claim. They're making land right claims and putting us in titles that keep us in subjugation, misnomers, etc. But they're doing it for the sole purpose so that they can negate our birthrights. See, this is why they don't want to adhere to who we are based on our national origin. Moorish, Moroccans, Moors, etc. They don't want to call us that or give us or we got to do it ourselves. But I'm saying they're not going to just give that title to us of our national origin because they know what's associated with that. Now what happens is it's like that pinwheel that starts working backwards because of everything that they did, saying in the past. Now it's going to pretty much start winding backwards. And now you got to remember, look at the dues, look at the debts, look at the arrears, look at the revenues and stuff that they owe pursuant to the peace and amnesty and commerce treaties that they owe the Moors. They gave us these new titles, like I said, to keep us in subjugation for mainly so they didn't have to adhere to the treaty provisions and international law. So once we get back into that, saying now we can make the rights, saying in honor, okay, and bona fide claims to the land. But without that, saying we can't do that. That's what this really whole thing is about, is that they're controlling our land, airs, waters, controlling our minerals and running industries on our land, using our airs and our waters, and then taxing us, but in our own homeland. And they can do that. Why? Because you identify with Black people, not you people, because obviously, everyone here doesn't do that. But when I say you people, generalizing most of our people, friends, pairs, family, etc., we identify as Black, Negro, colored, African American, Puerto Rican, Dominican, saying Jamaican, Haitian, etc. And those damn names have no standing in law whatsoever. So
Okay, back
that's
up what Mike is
the
saying
issue.
is a letter that France wrote to the United States. France wrote the United States a letter. France gave the name of the people they entered treaties with here in Morocco, called North America. They said Native Moors. Then they said Native American. Then they said Native Indians. Then they said Native Negro, Native Black, or Native Afro-American, or Native Africans. The French government called them Native Moors. They entered treaties with the Native Moors going back 1600s, 1500s, name it. France called the people Native Moors. So what's going on here now? The European conquest powers are calling the people Moors. And the United States, you know what? We will call them Indians. What just happened? You just took the Moor heritage, everything from it, just by labeling him Indian, because there's no treaty with the word Indian. All the Indian treaties are subjects of the crowns: Spain, Great Britain, Dutch, Portuguese, Netherlands, Spain, France. Under that name, Indian, that's birthright theft name, you consider a subject of the European powers. But we use the word Moors, that means that you're free, because the Moors are the free people of the ancient nations. So all through language, that gives a jurisdiction. Indian, Mexican, a Mexican is on their Spanish-speaking Moors. The political label they place on the Moor. Once the Pope, see, we gotta really pay attention to what's going on. The Pope, this new Pope is going out. Before he went out, he atoned for some wrong that the Catholic Church did. Somebody said, well, I don't care about it. I care about it. Yeah, I do. Because when a man opened his mouth and made the truth, that means a lot to me. The Pope admitted that they committed cultural genocide on the indigenous people. He didn't say more. He said indigenous people. So who he talking about? Most people say, oh, he talking about Indians. No, he not. He talking about Moors. Because before there was Indians, before there was Mexicans, before there was Nicaraguans, before there were Cubans, there was Moors. So the Pope was making atonement by using the indigenous for the Moors in Canada. But Canada is part of Morocco. It's a political territory of Morocco that Great Britain and France occupying. So the Pope opened up a can of worms. When he said,
He's getting. I'm sorry, Lord Shem, I didn't mean to cut you off. I just wanted to elaborate on what you said. I just want to elaborate what you said. Yes, he did. He dropped jewels, but he's still being how should I say? He's still being heavily watched, for lack of better words. You know, because I don't know to what extent he's being watched. But Pope Francis didn't make that statement, which is referring to. However, he was asked, because I forget what society, what a certain movement asked him to rescind I believe the doctrine of discovery, and he said, I won't do that. He said he's reluctant to rescind the doctrine of discovery. So on one prong, he's adhering to the cultural genocide that they committed against the indigenous people, but yet he's reluctant to rescind. So that would be the intent. He's reluctant to do the doctrine of discovery. So all that, the Spanish Inquisition, the Interterritorial Vita, he's reluctant to rescind that. So that's why we have to challenge that.
Well, the thing about it, Michael, when he made that confession, all I say benefit the unconscious Moors. Now to see how we got like this. Cultural genocide. He said, the Pope called it cultural genocide. How we got like this? How did cultural genocide happen? Going to their schools. Cultural genocide, because he used the school. He said the Catholic school system.
Wait a minute, hold on. Oh, wait a minute, hold on. My fault. I just realized something. Hold on. No, because my wife had just informed me that no, the person that asked him to rescind the doctrine of discovery, listen to this, Professor Abdullah, the people that asked him to rescind the doctrine of discovery was Indians. So he probably said no because he probably said no to the Indians because he knows that they're in their improper status. But when the Native Moors asked him to rescind it, I'll have to agree. So look who it was coming from. The source that it was coming from was from the Indians. Now, I'm not going to predetermine anything, but it was the Indians who asked him to rescind that. So the Indians don't have no standing because they don't have a right to a claim to land. So that's what it's all about. It's all about everything come back to the land. Now, if the Native Moors make that claim, like us, the Native Moors make a claim to rescind the Interterritorial Vita and and all of those papal bulls of the past that authorized Spain, Portugal, etc., to come now and tomb raid in indigenous Moors land. Now they have to, because now they've been officially charged, because the actual sovereigns to the land made a claim, not the Indian. The Indian don't have no stance. The Indian don't have no claim to the land. They British nationals by law.
Now I want to put a right consumption in the Moors' heads. Principle. See, we have to understand when empires are going to war against each other, whatever emperor overpower, beat the other emperor, all the territory that they got belongs to the emperor. It gets transferred. So when the Sultans defeated the Pope, and took over Constantinople, he took over the stronghold of Arabia, Moab, and Israel, in the land of Canaan. That's Morocco's the land of Canaan. All these superpower nations dwell in the land of Canaan. When Sultan beat the Pope out, he took over all the political jurisdiction of Denmark that the Pope had, the Roman states. They had in Africa, the political authority of Africa. The Emperor of Morocco took that all over. That's why they call it the Moroccan Empire, ultimate empire. So you got the ultimate empire with the war against another empire, a Sultan empire. They warring against each other. Now what happened is a lot of Moors are put on a servitude. See, we got to tell it right now. It was this European put us on a conquest. It was the head of an empire, emperors, of Moorish emperors brought Moors into subjugation. That's why they call Moors subjects. And nobody wants to talk about this. So the Moors put in subjugation before the Europeans got here by these ruler emperors. They were the one to extensive, like get the Europeans power to come in. The Europeans could come off a ship unless the Deys, the Beys, the Amirs, the Caliphs, or the Emperor of Morocco allowed them to come into treaty. When they got here, they realized the people was already subjugated by their own emperor, Emperor of Morocco. So therefore, whatever the emperor signed, that's how it is. This is the Fez Treaty. One of the treaties everybody should read called the Fez Treaty. Please read that. Read the Fez Treaty. It'll open your eyes of what I'm talking about. What's going on? While Moors are paying taxes in their own land. See, French, Great Britain, and Spain, Portuguese, they never lost authority. United States is you consider as an authorized representative. They represent all these European powers because the population of the states are French, British, Dutch, Sweden, Irish, all these different European descents are part of the state. So therefore, by being that way, they run the corporation for the European power and the conquest. Yes, they're the trustee for the Pope, for the European power, the United States. They're the trustee, special trustee. Why? Because all of them are Portuguese, French, British, French. They're Spanish. Yes, all of them. Yes, all of the European, Irish, all the states, and the government seat vote for each other. They're all of all the European powers. The father and mother came into treaty. They were given amnesty and asylum. All of them are the same family, same clans. So that they're allegiance to their government. This is why they have an election. A big turnout come out of the population of Irish, Dutch, Sweden, Portuguese, British, French, all come out. All these people come out and vote every year for state representative, governors. They're all of these European families.
Right. Well, the United States, yes, they are I guess the collectors, saying of revenues, saying on behalf of the European powers.
Real quick, we got DuPont. DuPont has had his hand up for quite some time.
I was just about to mention this.
Go, DuPont.
It's I don't know if Shem was reading my mind or not, but I wanted to get on the term of Indian. So Shem cleared all that up for me. And for those who's listening, the difference between calling yourself an Indian and calling yourself a Moor. but Shem cleared it up for me already. With that, I yield the floor.
All right. No other questions? You can put the hand down, DuPont. All right, good. iPhone, what's your name? I'm taking attendance. I'm taking the iPhone, I'm taking attendance. I'm taking attendance for our record. iPhone, what say ye? Just give me your name so I can put you down. iPhone. All right, we'll just go on. All right, go ahead. Michael?
Yeah, no, I just wanted to just say that that the United States are like the, they're like the collectors, of revenues on behalf of European powers. However, the Europeans, they're supposed to be actually paying taxes to Morocco. And, that has been established in the 1952 case that the United States is, they don't get the tax exemption. So along with losing most favored nation status, as illustrated in Article 15 of the, infamous Treaty of Peace and Friendship, that that treaty was superseded by the 1856 treaty. Under that 1856 treaty, under Article 4, it was agreed between the Britannic Majesty and the Sultan of Morocco that Moorish Moroccans in the dominions of the Britannic Majesty, as well as British subject to the dominions of the Sultan of Morocco, should have, should not be, subjected to any taxes or impositions whatsoever. However, that Article 4 was null and voided in a 1952 case. So United States do have an obligation to pay taxes to Morocco. So that is a large part to do, with a lot of the changes up post that case, in particular dealing with civil rights. It was like a decoy from, dealing with the denationalization to different, distractions to pretty much keep the people minds distorted and focusing on the wrong topics to get out of their plight and suppression. But yeah, that's an important detail, because in the treaty, it does say that that British subjects, it was agreed in that treaty that British subjects have a tax exemption, but that exemption was ruled null and void. They are obligated to pay taxes, and all foreigners pursuant to the Act of Algeciras, for that matter. The Act of Algeciras says that all foreigners are supposed to be paying revenues to Morocco, but there's no Moorish government, so they're supposed to pay to the Moorish government, one, and the 1952 case reconfirmed, and that was brought up in the 7th Franco Convention, that tax exemption was ruled null and void pursuant to Article 4 of the 1856 treaty. That is heavily important. The United States does not have a tax exemption. They are supposed to be paying their fees to the Moorish government. And my reference points on the Act of Algeciras for the United States.
Peace, brother. Peace. Hey, this is Shem Bay. How y'all doing this evening? Can everybody hear me?
Yes.
Can everybody? Okay, good. What would that look like? What would that process look like? I mean, I know that we can all come to formulate what that would look like in terms of resources. If they had to start paying us back our taxes next year, then what would that be in the you think that would be in the form of resources, or because we know that they're not dealing with we know that they're dealing with fiat. So like what in terms of initially reestablishing the diplomatic ties with the various nations, what do you think that would look like in terms of everyday life? Does that make sense?
Political control of political jurisdiction and our own resources, our water, our right to fish, have an industry in the fish, the livestock, and our own farming. That's the resource we want to get back out of the conquest. How you pay somebody back? Political control, political control, economics, and commerce, free trade without no interfere, political structure without interfering, and controlling your resources. What's your resources? Farming, livestock, and fishing, and your minerals, and your way of doing trade.
And that would open up the
That's
door for, us to do business with other nations too, and reestablish diplomatic ties and so on and so forth, without having somebody's hand. The whole what is it? What they say, Malcolm, get your hand on my pocket, Malcolm. And so,
well, government,
that kind of scenario.
Government structure will allow you, when you become part of the world body, automatically allow other nations of that signed to the UN to reach out to you. Remember, the Justice Department got an Interpol inside the Justice Department. That's the foreign army of all nations. See, what's going on now is a con. The media is pulling a con. They Jack the Rabbit. They like a magician. They talk lies, mischief, to throw the people off, so they can look in the wrong direction. See, the media, a lot of people boast all their stuff on what the media say, or the Daily News, or what they're saying. That's like heroin, crack, angel dust, information, language. So they're using the people through false media to throw them off. Like right now, they're talking about China like a dog, but in bed, diplomatically in bed with China's money-wise, bond trade, exchange, they're in bed with them. But they talk about it in the public. Nobody talk about it because they want to put it in our minds that these people are evil. So anybody that say evil, keep the so-called moral black ignorant. So he walk around hating his own people, hate the nation that's for them. So they don't give us any aid. They hate us. We walk around hating them. We don't know nothing about them. We don't know about ourselves. We don't know who we are. We talk about these people. We don't know about ourselves.
So with that, I'm sorry, I didn't mean to
Follow
cut you
the
in,
money.
so
Follow the fiat. They're telling lies. And they
most
are
definitely.
not, you cannot trust them people because they honor no contracts. Watch the money. Watch the money. Watch the fiat. I ain't even gonna call it money. Just follow the fiat.
In that energy, study as a reference.
So you got the Hittites, Canaanites, the Moabites.
Raise our hands. Raise the hands. Use the hand raise.
Hold on. I can find it.
This Abraham, they came from.
Raise your hands.
Who was saying that we gotta watch the people? We can't trust those people. Who said that?
That was Albert L.
Okay.
We got Sheen's hand is up. Sheen.
Yeah, brother, can you hear me?
Yes.
Islam, I apologize. I wasn't trying to like cut anybody off. I was just in the moment, and I wasn't trying to be rude to anybody. I was just saying a good reference for being able to see, because I know that reference, because we have to be able to defend our position. And I feel a certain responsibility for the implications that it has on other people that look like me. And so Welch versus St. Helens, we were talking about as far as financing, but there's a case, Welch versus St. Helens, that basically talks about how the ruling of the court was the fact that, hey, they are still paying taxes to the United States. Is currently still to this day paying taxes to Great Britain. So I just wanted to drop that reference real quick in the heat of in the spirit of what we were. So I just wanted to share that so everybody can be able to research and verify and make it their own.
Right. And they're supposed to be paying taxes to Morocco too, but we got to get the Moorish government.
Any questions? Any other questions?
I do have something that I'd like to display. Give me 1 second, I'll share my screen. Just going back to post-millennium, Abdullah. Give me 1 second here. I'm going to share that right now. Can everyone see this?
Yes.
Okay. So this comes from the book of the Law of Nations. What's his name, Abdullah?
Emir Vital. Emir Vital. Vattel. Emir Vital.
Yes, there you are. And this is what I, when we were actually in that part of the conversation, early on, I did display this. I wanted to display this so everyone can see. And it talks about the post-millennium, context of international law.
Can we read it? Can we read it?
Absolutely. Can we have a reader?
Amanda.
Yes.
There she is.
Chapter 14 of the Right of Post-Millennium. Section 204, definition of the right of post-millennium. The right of post-millennium is that in virtue of which persons and things taken by the enemy are restored to their former state on coming again into the power of the nation to which they belonged. Section 205, foundation of this right. The sovereign is bound to protect the persons of the property of his subjects and to defend them against the enemy. When, therefore, a subject or any part of his property has fallen into the enemy's possession, should any fortunate event bring them again into the sovereign's power, it is undoubtedly his duty to restore them to their former condition, to reestablish the persons in all their rights and obligations, to give back the effects to their owners. In a word, to replace everything on the same footing on which it stood previous to the enemy's capture. The justice or injustice of the war makes no difference in this case, not only because, according to the voluntary law of nations, the war, as to its effects, is reputed just on both sides, but likewise because war, whether just or not, is a national concern. And if the subjects, I lost it, Terrence.
Oh, I'm sorry. Am I actually moving? I was trying to find my screen here. I'm sorry. Oh my goodness. Here it is.
Okay, here we are.
Sorry about that.
That's okay. It is the same as if, okay, sorry. The justice or injustice of the war makes no difference in this case, not only because according to, not only because, according to the voluntary law of nations, the war as to its effects is reputed just on both sides, but likewise because war, whether just or not, is a national concern. And if the subjects who fight or suffer in the national cause should, after they have either in their persons or their property fallen into the enemy's power, be by some fortunate incident restored to the hands of their own people, there is no reason why they should not be restored to their former condition. It is the same as if they had never been taken. If the war be just on the part of their nation, they were unjustly captured by the enemy, and thus nothing is more natural than to restore them as soon as it becomes possible. If the war be unjust, they are under no greater obligation to suffer in atonement for its injustice than the rest of the nation. Fortune brings down the evil on their heads when they are taken. She delivers them from it when they escape. Here again, it is the same as if they had never been captured. Neither their own sovereign nor the enemy has any particular right over them. The enemy has lost by one accident what he has gained by another. Section 206, how it takes effect. Sorry.
All right, so we don't have to read them all because it's pretty lengthy, but I just wanted everyone to see, and I did post the link in the chat so you can actually read this for yourself. And so, whether it takes effect among allies of no validity and neutral nations, so it breaks it down for you. And I just thought that this was an important piece for everyone to, to take and absorb. Do you want to go in on this at all, Abdullah? Abdullah, are you there? Uh-oh.
I'm here. What's the question?
All right. No, I was asking if you wanted to say anything about or talk about the post-millennium.
Again, yes, as I said earlier, post-millennium, and I talked about it in the context of what post-millennium is not.
Mhm.
The 14th Amendment is not post-millennium. You have a people who've been captured, who's been subjugated, whose state, the Moroccan Empire, their political state has been collapsed, disintegrated, dismembered due to European conquest, the Spain, France, Portugal, Great England / Great Britain, the Netherlands, and include that in the Dutch Republic. Through a series of wars, and then you go back to the Crusades against the Moors, launched in 1095 by Aragon and Castile and France and England and Germany, and Spain and Portugal. So through a series of wars, we were brought to our knees, as well as the Ottoman Empire was brought to her knees through that Treaty of Lausanne. All right, dismembered the Ottoman Empire, the Treaty of Lausanne of 1912, 1923. In fact, I read last week that it's actually up in 2023. So we have to look at what our condition is that we have a collapsed state. We have a collapsed state. We have a people who belong to this collapsed state by national origin, consequently descent. We have people who've been subjugated, whose land been under conquest by Spain and France and Portugal and the Netherlands, Great Britain, and whose people has been subjugated. So the 14th Amendment, so what Congress did was legislate the 14th Amendment to maintain the subjugation of the Moors. Now, our people not knowing who we are, think that this 14th Amendment made us citizens. It gives us now, some identity and some connection to the United States now. So we hold that dear because we don't know who we are. The United States is making claims over us based on the 14th Amendment and the state's birth certificates. And I know that there are conscious Moors who address the state's birth certificate as a commercial instrument, which it is, but I'm not going to address it in that context today. Commercial instrument, all right? I'm going to address the context, the birth certificate, the state's birth certificates, and the context of international law. All right, what is the birth? What are the state's birth certificates? That means those states that belong to the Union, State of the Union of the United States, birth certificates. How do you analyze that in the context of international law? Once you understand who you are, yes, our mother lay in the hospital. She's in a coma. She needs to be resuscitated. She's on life support. In international law, that's called a dismemberment or collapse or disintegration of a state. But we have we have the inherent power to recover our lost Moorish sovereignty. We have the inherent power to exercise the pre-existing Moorish sovereignty that was once exercised by the caliphs, by the emirs of the Umayyad dynasty, of the Almohad dynasty, of the Almohad dynasty, going back to the 700, 800, 900, 1100s. We have the inherent power. We have to exercise the Moorish sovereignty exercised by the Bashars and the pashas, and the sheiks, and the emperors, and the beys, and the days. We have the inherent power to resuscitate our mother. United Nations don't give us that. We do not need the United Nations permission, because that's a misconception too. Let's clear this up. We do not need United Nations to sanction us to resuscitate our mother. If you acknowledge that the United Nations has the power and the authority to sanction you to resuscitate your mother, that means you're acknowledging the United Nations as the sovereign over you. That's an inherent power. That's an inherent power. What do we need, Abdullah? Our people. They're homeless. They don't know who they are. They're on drugs. Not all of them. You know, they're poverty stricken. You know, not all of them. They're classified as Negro, colored, Black, Latinos, Spanish, Indian, Mexican, Nicaraguan, Dominican, Cuban. That's who they are. You need them. You need them. You don't need the United Nations. United Nations don't have that authority. United Nations has no authority to resuscitate your mother. The people have the authority in their collective capacity, in their collective sovereign capacity to resuscitate our mother, not the United Nations. The sovereignty doesn't belong, more sovereignty does not belong to the United Nations. I'm emphasizing that because there's been misconceptions. There's been misconceptions. So that's why we have to clear up misconceptions, we clarify. So what I do in Moors and Masonry Part 2, Chapter 11, beginning with Chapter 11, it was a Chapter 11 or Chapter 9, Moors and Masonry Part 2. I'm trying to remember all. As I discuss the 14th Amendment and the state's birth certificate in the context of subjugation, and it's not an act of post-millennium. And post-millennium, as Amanda read, deals with restoration, returning to that condition or state as if you were not conquered. The 14th Amendment doesn't do that. All right, hold on. So we were subjugated under European powers? Remember, we're not analyzing things in the context of international law. And this misconception that Moors, 35 Moors established the United States, and 35 Moors with the United States Constitution, we the people of the United States, that's the Moors. Those are misconceptions. So what has done is inhibited the growth of this Moorish movement. The misconception has been out there for over 100 years. And until I reconnected with Shem Malachi Bey and 3.5 years ago, the misconceptions reigned. It reigned. Yours truly taught misconceptions for 25 years. It reigned. And if it wasn't for Shem Malachi Bey, the misconceptions would still be reigning. So I want to thank Shem Malachi Bey because he's the reason why I revamped Moors and Masonry Part 2. I revamped Moors and Masonry Part 2 been back on it for 9 months. I revamped the whole book. Shem Malachi Bey. Thank you, brother. Anybody there? Can you hear
All right,
me?
we do have a
All right.
Doreen Tucker. Hand up. You have the floor. Doreen Tucker, if I'm saying it correctly.
Shem had to leave out? Yeah, he had to leave out. All right. Is Michael still on? So Michael and I will run the show.
All righty.
Dean Tucker may not know.
Yeah,
Okay, there.
yeah, Darian
right.
Tucker.
Here we are.
I'm totally blind, so I had problems unmuting myself. So what I'm going to request is the treaty that I think it was Shem he was mentioning. All I remember is 1856.
Yeah, 1856 General Treaty between Morocco and Great Britain. I do have that, brother. I can text it to you or email it to you. I have everybody's names, but I do have some people's email numbers. I mean phone numbers, but I don't have everybody's phone numbers. I have about the list. We got 21 on this list. I need the iPhone. iPhone, what's your name? iPhone, what's your name? I have everybody's name except iPhone. All right, we're gonna be taking attendance every week. I'm gonna be typing this up so that we can have a record.
iPhone is Kawasi L.
Kawaza?
Kawasi L. KWASI.
Spell again?
KWASI.
S-I.
Space L. E as in Eric. L as in love.
Yeah, Kawazi. I got you. Thank you, brother. Thank you. So we can have this for our record. All right. So Darian, what's your number?
Yeah, so my phone number is 706.
Hold on. Whoa. Put it in chat. Put it in the chat.
Okay.
All right, we'll put it in the chat.
Okay.
Yeah, this is going on YouTube, so.
Oh yeah, that's right. Yes. Put it in the chat, brother. Yeah, you don't want that's right. Thank you, Terrence. Yeah, this is gonna be on YouTube, y'all. It's gonna be on YouTube and
for real.
Oh, we got it up here. Somebody put the somebody put it up there, brother. How'd I see that? Go to more. Did somebody
Yeah, everyone have permission to
okay, that's good.
rename themselves during the meeting. So
there's somebody upload. Did someone upload the treaty? Kawaza uploaded the treaty. Yeah, it's up there, brother. It's in the chat.
Okay.
So I don't have to send it out, but I got your number anyway. The treaty is in the chat. The link to the treaties in the chat room. The link to the treaties in the chat.
Okay.
Thank you, Kawaza. We all working together, man. One great plan. All right, any other questions? Just go to the chat to get the treaty, y'all. That link to the treaty, the 1856 treaty between Morocco and Great Britain. Any other questions? Michael?
Don't put the Treaty of Algiers. Don't put that on the back burner, and don't put the equity law on the back burner. I'm not finished reading everything about it, but I think you touched on some good points last week. I'm not done reading. I got some stuff that I might have to say about that coming up next week or so. That's very important. I think I don't know how to raise. I'm trying to figure out how to raise my hand on this Zoom thing.
Go to, you got more, you see more?
Okay, hold on.
More, and you hit raise hand. Well, that's what it reads on mine. You have to go click on the bottom. Are you on your computer? All right, another question?
Yeah, I just uploaded a PDF of the general treaty between what is it? Oh, wait a minute. Was that the
Morocco and United States and then Great Britain?
Yeah, in Great Britain. Yeah. Just 1856 treaty. So that's a PDF.
Any questions for clarification? Any questions for Michael? Anybody have any questions for Michael? Any questions for Michael? Anything you want him to clarify?
Islam.
Yes.
This is Lauren. Michael, I had a question in regards to, you were referring to a criminal case that you were, I don't know if I'm saying the right word, representing the Moor or a Moor in regards to attending the court session via Zoom. Are you there?
That was two separate charges.
Wait, I'm getting an echo. Michael?
Michael, you're getting an echo, yes.
I'm getting an echo. I really can't understand or understand anything he's saying.
Can you hear me now?
I can hear you better.
Can you hear me now?
Yes, I can.
Okay. All right. Yes, that was two separate instances. Yeah, that was a criminal case. It's a criminal case, and I had a couple of cases. But that criminal case, what was your question on this?
Okay, regarding the criminal case, I wanted to find out how you were able to attend the court proceedings via Zoom.
That was criminal.
The reason I'm asking is that wait a minute. I'm sorry. Maybe I need to move around. Could you repeat that?
Yeah, the civil case is the one I was in attendance of, and remember, it's kind of like letting the natural to do it because it was up that way.
And Michael,
something's wrong because it's really
Michael, you had to somehow with your phone, something's going on. Is you're breaking up you're still a little distorted.
Okay, where I'm looking, there's no one around my.
Wow.
Oh, okay. Well, maybe it's on my end.
No, it's on his end. I heard this. It's the same. It's on his end. You fine. You sound fine.
All right. This is what I'm gonna do. Tell me, is it better? I'm gonna use my cellular data as opposed to my Wi-Fi connection. Can you hear me better now?
Yes, I can hear you now.
Okay, so I was on my Wi-Fi connect. Now I'm on my cellular data. Okay.
All right.
So what was your question?
All right. Good.
Okay. My question is, you attended a criminal court proceeding via Zoom.
No.
My question is,
civil. No. Hold on, correction. A civil. But do you remember the details of why I attended the civil matter? You remember the details?
I do. I recall you saying something regarding to the lockdown and COVID.
Right. So they had that option. Right. So, go to your question.
Okay, and that was my question. I have a criminal case that I'm assisting a Moor with who is incarcerated. He's got a court date coming up because his attorney has resigned, stating conflict of interest because I'm assisting him as a sovereign lawyer. Now, my question is, I'm in Dallas, Texas. He's in Richmond, Virginia, which is quite a ways away, and I cannot be at the, physically at the court proceedings that's coming up. So my question was, is if you were able to attend via Zoom as consul, which, I would like to attempt to do, but my question was, how could I do that? Or if that's even possible.
Okay, well, that's a funny, it's a funny situation with that one, because he's already in custody. Not saying it's the end of the world, but here's the main thing. You can't represent him. Well, okay, you can't represent him, okay, in a capacity of, because he's in pro se. He's basically, saying I'm pro se, and you would be in pro se too, because of the status conflicts. Remember, you have under the Constitution, under the Sixth Amendment, you do have the right to defend yourself under the Sixth Amendment of the Constitution. But remember, that's not the secret is that's not applicable.
Well, that is correct under pro se status. However, he is in propria persona.
Propria persona, right? But he doesn't remember.
As I am as well.
It's a twofold. It's a twofold, and he could potentially get jammed up. It's really depending on if you don't mind, you didn't give me the name, so it don't really matter. So you can tell me the offense, because we don't have the person's name. What's his offense?
Oh, I would prefer not to disclose that information publicly. I mean, there's no injured parties, but that is something that I, as a sovereign, would prefer not to indulge.
Okay.
Publicly.
So there's no injured party, and you're representing him. So I would say, because the first thing, I'm gonna give you two. I'm gonna give you the qualifications for what I'm doing versus what you're doing.
Michael,
And
can I stop you for one quick second? Because I don't hate, but I do not use that word represent, because as sovereigns, no one can represent a Moor. A Moor can only present himself. So I am assisting him as a sovereign lawyer.
All right, let me.
Right.
Hold on,
yeah.
Lauren, real quick, Lauren.
Islam.
Let's qualify this. Let's go to the Moorish treaty. All right. I know you.
Right.
I know where you're coming from.
I was just about to say that.
I know where you're coming from. I heard that 25 years. What she said, I've heard for 25 years. All right. We can use the word represent. Moorish government.
Okay.
I'm talking about Moorish government. And then
right.
Moorish
because
government,
the treaty, the treaty authorizes the consul to represent their national.
The consul. Okay. Yes. Thank you for correcting me, though. Thank you so much, because that really did enlighten me. Because I was like, they can't represent us, but we can as consul.
Right.
Oh, okay.
Right. Pursuant to the treaty provisions, only the Moorish government, it says the Moorish government or Moorish consul or Qadi can represent the Moorish subject. No British, right. And as it pertains, and in like manner, when a British subject has an issue, when a Moorish subject has an issue with a British subject, only the British consul or vice consul or consular general can assist in that matter. Right. So basically, each nation represents each national of their nation. So that's to be correct. Now, what I was saying, in his case, it's okay. So yes, he can under the Constitution. This is also about saying to be careful of. Just be careful.
Wait. You said under the Constitution, because he's not under the Constitution. They are under the Constitution.
Right. But they listen. But listen. But what I'm saying is that you listen. Just listen when I talk. Just kind of like just visualize each step of the way. No. Just visualize each. Not necessarily be quiet, because I want you to be responsive when I ask you a question. But I just want you to analyze, saying the situation, the criticalness of where he's at. Right now, he's currently in their custody.
Yes,
so that's that right there. Okay, so right now he's vulnerable, and so are the people whom are dear to him, and vice versa. So how you handle it now, right? He has to request for consul. He would have to request for consul, right? He had an attorney. Now I'm assuming the attorney that recused himself. Did you guys recuse him, or did he recuse himself?
Well, when he first started, he didn't know anything about this, so he was just kind of teetering, and when he went to court, I had submitted documentation to the court, and he asked me to submit the same documentation that I was submitting to the court to his attorney. He gave me his attorney's email address, and I in turn forwarded all of the documentation to his attorney to make his attorney aware of what was going to the court. The attorney in turn forwarded to the prosecutor, which that, you know, I mean, I can't tell him what to do, but I would have preferred him not to, but he did. And they were discussing the paperwork in court. So his attorney, after I sent another set of documents, because I think maybe 4 or 5 days later, I sent another set, I think it was a writ of discovery, and his attorney went to to the jail to visit him and told him that he was going to resign from the case because it was a conflict of interest. They did go to court, and when they got to court, the attorney stood up in court and stated the same.
Okay, so sound like to me.
Let me finish. I'm sorry, Michael.
Okay.
Let me finish.
Go ahead.
The judge then put him on I hope I'm saying this right, a standby docket. And somehow he found out, and I don't know how he found out, so I'm just going on what he told me, that he does have a court date that's coming up on the 3rd of September, and that court date was to set a trial date. And that is what I was in hopes to prevent.
Okay, to set a trial. Okay, now did he request for trial, or did they push the trial for him?
He absolutely. They tried. The attorney that recused himself was very angry because he wanted him to take a plea.
Hold on. Right, listen. Hold on. Listen to the question. Did he request for trial, or did they go for push for trial?
I'm gonna have to verify this, but from what I can recall, that he did not want to take the plea. Therefore, he wanted a trial by jury, but I wasn't there, so I just need to ask him again just to make sure I'm understanding it correctly.
Okay. All right. So, because usually in the cases, let me just say this to you. Usually in cases, when they arrest you, whatever, and they brought you in a criminal gauntlet, they don't want you to go to trial. They want you to take a plea bargain. Number one, because they don't want to go through the process and expenses of, saying impaneling, because you got to impanel the jury and go through that whole process, stuff like that. Now that costs, saying, and that also could be also just, you got to remember that also going to trial could also, because you got to remember, he's in a criminal gauntlet, right, for a crime.
No.
But hold on. He's in a criminal gauntlet for an alleged crime. But a crime only exists when there's an injured party under the Sixth Amendment. So why they got it? So why they got? But I didn't get the last part. Okay, I'm sorry.
The crime only exists. Yeah, I'm sorry. You said the crime only exists, and then it dropped off. I couldn't.
Okay. Sherrod versus Cullen case law, Sixth Amendment of the United States Constitution. And I'm just giving you so I can explain his current situation. Then I'm gonna give you what your options are. Saying from that standpoint. The Sixth Amendment of the United States Constitution requires that for a crime to exist, listen, for a crime to exist, there must be an injured party. There must be an injured party. Now, the first thing you told me when I asked you about his offense, you said there's no injured party. So Sixth Amendment, so they got him in a criminal gauntlet. There's no injured party, right? Now, so now here's the fact that they running what they doing and they adjudicating the matter. One is your conduct. There's two forms of contract. There's two forms of contracts. There's express and there's implied contract. Express, I could be verbal or written. Implied could be through your actions. So apparently you're contracting with the court right now based on your conduct. So you're showing an express and you're showing an implied contract through the court's eyes. So you're contracting. Now they have him in custody. The reason why I asked you if they asked him, saying, did he say, I want to go to trial? Saying for this is because if he want to go to trial right now, here's the deal. That could be tricky because you don't want to have, saying you don't want to blow trial because then he could be in trouble. The thing I would suggest for him to do is to, if I were you, I would get the particulars. Okay, because he had a paid attorney, right? A paid attorney recused himself. Did he paid the attorney, or it's not a legal aid, right? It's a paid attorney.
That's another thing I need to clarify. I believe it's a paid attorney because I know when he was stating before,
Okay,
of
then
course
he can't just, okay, so he can't,
Well,
okay, then he just can't recuse himself. He can't just
I'm
recuse
not
himself. Okay,
sure. I'm not sure if it was a paid attorney or an appointed. I'm just
Okay,
not sure. I
okay.
think it was a paid. I'm just telling you because he's talked about
Okay.
getting a paid attorney because he was
Okay,
confused.
okay,
Anyway.
okay. Wait, okay. So you said he's talking about getting a paid attorney, or you think he was paid?
No. After the court date happened and the attorney recused himself, he's so new to this. Of course, his mind was all over the place. So he was saying, if this is not working out, then maybe I need to get an attorney because when the judge put him on standby docket, I went and did research on when they do that, and it could go on for up to like 2 years or more.
Right,
As far as
right. Because
putting
what
him
they'll try to do, right? Because what they try to do, and then I have this firsthand experience. Saying what they try to do when you don't take the plea deal or what they're trying to offer you, the prosecution is offer you. This is what they do. This is the type of shit they do. They'll drag you by language. They'll drag the listen. They use it's called psychological warfare, psychological coercion.
Right.
They drag the court case out. Now, if you already in their custody, they're gonna hold you. They'll say this is because this is the psychology that they're using. He or she is gonna sit in that cell, right? And they get because we got all the time in the world. We writing the bonds anyway, saying to pretty much to have him or her occupied in that damn vault, okay, and that's safe because the jail is equivalent to a vault, okay, or a safe. They're running that they will keep that person in there until they capitulate and take one of these deals. So either way, we're going to eat off the bond. So now that's what they do when they run in bonds, and that's what they writing bonds, okay, and they doing trading. That's what they do. That's how this is what they're doing.
It's a business.
Now,
I get it.
Now,
too.
okay, right. Now, so what I'm saying to you is this. The reason why I was asking you about the trial, you need to find out two things. And then I'm gonna tell you which option is. Find out if his attorney was a paid attorney or legal aid, because the legal aid wants you to take a plea deal. They don't want you to go to trial. The legal aid, saying this, but here's the deal: when you get a paid attorney, the paid attorney is paid. Now, this is where contract law comes into place. This is where ethics. Now, no one will ever tell you this, but saying I'm gonna tell you this because I got this to school, going through the criminal civil gauntlet in the years past. Attorney paid or legal aid, their first obligation is to their bar license, so to the Bar Association, the American Bar Association, which is under the umbrella of the British Crown, Esquire. Their first commitment is to the bar. Their second is to the courthouse. So the courthouse is where saying that the cases are taken, and then the third obligation is their defendant, their client. So keep that notion in mind, right? So now, what needs but when it's a different conduct now based on ethics when you have a paid attorney. So when you have a paid attorney, you're paying the attorney to pretty much do what you tell him to do. Now, in this particular case, if he's going to get a paid attorney, you need to find out, if he gets a paid attorney, the attorney has to do exactly what he's telling him to do. Okay. In other words, you want to go, you would tell him to tell, because remember, the attorney can only assert things from the Constitution and for the stat, because they're under, United States laws. That's what they assert. That's the only thing they can assert. That's why when a treaty is in international law comes into play, they have no jurisdiction to talk on that matter. So they usually just don't talk, the judge or whatever. But when you got a paid attorney, right? Because you got a paid attorney, they're running the jurisdiction based on conduct. So you got a paid attorney. So so now we're gonna pretty much run this case based on the Constitution. So now what you would have to tell him to do with his paid attorney, you'll tell the male, tell him more. Okay, well, if you're gonna go the route of getting a paid attorney, to tell him to tell his attorney that you want to go for full dismissal on the fact that there is no injured party pursuant to it's a violation. The charges that they got me on is in violation of the 6th Amendment of the United States Constitution. Sherrod versus Cullen. Okay, res judicata. Okay, tell him now. Let me say. Listen.
We do have a question on the floor.
Hold on. Let me say this. That's not it. That's not it.
Let him finish. I know we got a question, but let him finish this process. So this is
that's not it. Number two. What'd you say your name is again?
My ward name is Lauren, but my appellation is Rael. It doesn't matter,
Okay,
Tommy.
Lauren, okay. So Lauren, also this the second thing you tell him with his paid attorney. You tell
Well,
him
listen,
to
he's not trying to do that now, but I just, I had put that out there because he was confused at the beginning. But
see
if he should go that way.
okay, see, but all right, okay, but if he should go, okay, I'm gonna say this. Once you give the court jurisdiction, when you give the court jurisdiction, okay, when you give the court jurisdiction, and you start now going and moving, saying, like I said, without the help, this is the thing, because this is the thing that happens, like I said, when you go you coin it pro se, they're gonna put your shit on record as pro se, whether you're in propria persona or pro per, they're gonna put you on their filing as pro se because you're not a barrister. No matter what, I've done this shit before. Myself and Akeem been done this shit before. You ever heard that? Remember when Hov said, remember Jay-Z did that record? Nah, Hov did that. So hopefully you don't have to go through that. I was raised in the projects, roaches and rats. So basically I'm telling you some shit and telling you to tell your man some shit so he don't have to go through that shit.
Please, language.
Okay, so forgive me, Terrence. I was just being, basically,
that's okay.
Emphasis. I was putting emphasis on what they doing because they put all kind of burritos in your butthole and sorcery in that damn courtroom. Okay, so now what I was trying to say, if he goes to the route, I don't recommend him to take an attorney, especially since you're not sharing with me his defense. I would say get an attorney, get a paid attorney.
I can call you one-on-one and we can talk. I mean, that's not a challenge for me at all. I just don't want to divulge the information to public.
Because
I mean, maybe I got
you. But just let me finish saying what I'm gonna say because I got things to do too, sister. So I just want to share, say what your options are. If he goes the route of pro se, two things need to be emphasized with his attorney. When you get the paid attorney, like I said, the code of ethic now is that you got a paid attorney. So I'm paying you to represent me. So you need to do what I tell you to do. Now I'm giving you the points now that he has to tell his attorney that his attorney can't even refute. This will be irrefutable evidence that his attorney can't refute. Number one, the Sixth Amendment requires for the Sixth Amendment. Now remember, United States Constitution, dealing with the United States political zones, the United States Constitution is the highest law. It trumps the federal laws, state laws, and statutes and codes, because the United States Constitution, upon which the United States was founded on. So under the Sixth Amendment of that Constitution, it requires that for a crime to exist, there must be an injured party. There are the case precedents on that, Sherrod versus Colored. Read that case law. Now, the second thing he needs to say is this. Now remember what I told you, the key things, yes, he's a Moor, but just relation that for a moment. He's got an attorney, right? And the United States court is prosecuting him, right? Right? Yeah. Okay. Yeah. So now let me hit you with this jewel. When they arrested him, did they have a search warrant? Because under the Fourth Amendment of the Constitution requires them to have a warrant for his arrest. Where's the? So you need to say you need. Okay, hold on. Listen. I'm giving you. Listen. Now the second thing you need to say, he needs to tell his lawyer, because this is what listen to why I'm telling you this, because this is what the lawyer is going to ask. This is what the lawyer has to ask the prosecutor. I need to see, you need to, pursuant to the Sixth Amendment of the Constitution, I need to see the injured party. Where's the affidavit of sworn testimony of an injured party injured? Oh, there is none? Okay, boom. All right, number two. Okay, number two. Yep. All right, number two, he needs to ask, I'm going to need, pursuant to the Fourth Amendment of the Constitution, which deals with unreasonable search and seizures under the United States Constitution, I need the prosecution to relinquish to me. I need to be furnished. I need to see the affidavit. Okay. Show me the affidavit. Okay. The sworn affidavit statement that activated a warrant to come and arrest me in the first place. Because under the Constitution, that's what it requires that they have. In order for them to make an arrest, they got to have a warrant with a sworn affidavit alleging so and so. Where is the sworn statement in the form of an affidavit attached to a warrant? That's what you need, because that's the Fourth Amendment requires that. So this is what I'm saying. So if there is no injured party, there's no crime. Sixth Amendment validates that. If there is no warrant, with an affidavit, matter of fact, let me read what the Fourth Amendment verbatim real quick, if I could just, bring it up. Let me see what the Fourth Amendment, so I can just tell you how to express it in detail. Now, keep in mind, this is not something that you do with your Moorish structure, because you ain't supposed to be doing that. But you're just gonna, for the sake of his circumstance, Just give me a second. I'm just trying to find. Let me just look this up real quick. Just hold on real quick. Okay. Let's see, Fourth Amendment. Okay, the Fourth Amendment. Hold on, the Fourth Amendment. Okay, the Fourth Amendment says, okay, secure from a regional, it protects, okay, where's the, okay. The right of people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Okay, here's the secret. Okay, cool. So when they arrested him, just like when they arrest our Moors, for whatever the case may be, 9 out of 10 times they don't come with warrants, or, but it's just, it doesn't just say a warrant. Where is the it says unreasonable seizures and searches shall not be violated, and no warrant shall issue but upon probable cause that is supported by oath or affirmation. So that means they have to have an affidavit sworn to or affirmed to of their complaint attached to a warrant. You need to see that. I need to see the sworn affidavit attached to the warrant, okay? Talking about the nature and cause of the issue. Listen, that exhibits the nature and cause of the issue, and I need to see the injured party pursuant to the Sixth Amendment. If they don't have either one of them, which most likely they didn't do neither one, they ain't got either one of them, or you only need one of them to get the case dismissed, or to get the case significantly reduced. Now remember, you're already dealing with it, right? So I'm just giving you the option while you're already dealing with the court already, because he's in the custody of the court. Okay, so those are your options. So those are the options for the attorney, right? Now that's okay. So now the second option that you have is that you can actually remove his case into the Fed, and then he automatically gets treated under the Constitution anyway, but he has to come under refugee status, because really that's what he is. Now, you don't. Yeah, Moors, right? Moors with no. While we have no Moorish government, no Moorish government, no political states, etc., we're in refugee status. Black, Negro, and colored basically is another way we're in refugee status, because we have an exterminated government. So what you can do now, because you can have the case removed, you can do a notice of removal, move it to the Fed, and then have. I'm sorry.
I'm just saying I'm probably gonna have to talk to you one-on-one.
Yeah. So you could, you're right. So you
can
do it that way.
Excuse me. Can we continue this? Can we continue this later? We have 2 minutes left, and we have one hand up. We have one hand up. Can we continue this?
All right. So we're going to take this. We're going to take Darian Tucker's question, but this is education for everybody. This was education for everybody. This will be placed on YouTube. It's not just for Lauren. This was not just for Lauren. This was not just for Lauren. This is for those who are listening, to the thousands who will be listening, not just for Lauren.
Thank you, Brother Michael. That was a lot of information, and
we got Darian Tucker.
For that, we have Darian Tucker. You have the floor.
Yes, peace. I just wanted to know, is there like any one point of contact person that I could like contact like on the go, like when I'm doing my research and I just need my question asked about something I'm looking at?
Michael.
Oh yeah. I'll put my website information is on the chat. So yeah, the Divine Envoy for Yahweh, that is on there. So if you have any question out my email, when I'm in contact, phone number information is on that website.
Okay, thank you.
Right.
Abdullah, you're muted.
You put in the chat today, Michael.
Yes. A few minutes ago, like 25 minutes ago, half hour ago.
All right, 25 minutes ago, you put in the chat. All right. We got 9 minutes or 8 minutes. Any more questions? Darren, you can put your hand down. Any other questions? Got time for about 1 or 2 more questions. That was really good exchange, Michael. Good exchange. Morning, Michael. All right, and let that go because that's an educational process. So people need to hear that.
Right.
Absolutely.
Yeah, I had a guy, you know, saying, because remember, conduct is everything. You know, they running contract law in the courts, essentially. Yes, you know, when a treaty is expressed, yes, they have to go with that. But remember, they're dealing with 99.9% of the time to 100% of the time. No one coming in any courtroom, whether it be federally or a circuit court, no one's coming in there, you know, saying asserting anything regarding no damn international law. So I was giving her the option based on the status quo. The status quo is he's in their custody. And the status quo, he's not part of any state or, you know, social, you know, or government body of politics. So I was giving her the option that she has based on him already being in a situation. Okay, well, cool. Since his conduct by contract is acting of a United States citizen, okay, so now here's his options, and his options are great paramount if she listens to what I tell her to do. I had a guy I was helping. He had a paid attorney. I'm gonna make a long story short. He paid his attorney over 2 years. His case got dragged out over like 2 years, and he had paid like an excess of 18 grand to this one attorney. And the attorney kept trying to get him to take plea deals, jail time, take a charge. Now keep in mind, this was his second offense. I told the dude, I told him one thing to do. I believe it's one of the things that I told him. I think I told him, because he got arrested, and I told him to ask for one thing, because now remember, this is why I said it could work to your benefit when you have an attorney, Lauren, when you do what I'm telling you to do, is because remember, now you have the attorney representing you. Now, but the attorney, once he's paid us, see, a legal aid doesn't do that. A legal aid, you got to remember, it's dealing with equity. Equity, you know, saying is, you know, the word equity deals with is a certain code of ethic, is a certain morale associated, because you're paying them equity to represent you. So now they have some type of fiduciary obligation to you because they're being paid by you. So I told him to tell his attorney, I told him one of those things that pertain to his case. The dude calls me up. I remember it like it was yesterday. This is about 5 years ago. He calls me up. I'm at my job, right? On my job, right? And he's like, yo, bro, I just want to call you just man, say thank you so much, man. He's like, yo, I did what you told me to do to my attorney. His attorney told him, give him like $800 more to do it, right? So it's a commercial game they running. He went and asked the attorney, right? Now, keep in mind, he was facing a misdemeanor charge and 9 months in the county. So they was gonna give him a criminal conviction, give him 9 months in county with a misdemeanor charge. I told him one thing to do, and they came back with 24 hours community service. He said, I took that shit and ran with it. No record, no adhesions, the 24-hour community service, and he walks. Case dismissed after the 24-hour community service.
Thing, Michael? What was the one thing?
The one thing was, I told him, remember, he's a Moor, but he's a Moor acting as a United States citizen, hiring an attorney. I told him to tell his attorney, when they arrested you, did they produce an affidavit attached to, you know, saying a warrant attached to an affidavit, basically accusing you of whatever, any sworn depositions or affirmations, whatever? Tell them to produce that. Tell the prosecutor that's bringing claim against you to produce that. And if they can't produce that, you want a full dismissal. When his attorney went and asked the prosecutor for that, the prosecutor said, we don't have that. Ask him if he'll take probation, if he'll take community service, not even probation, community service. Community service, people, that's just a violation. That's not a misdemeanor, that's not a felony, that's not nothing, that's a violation. It's considered a violation. And basically you do 24 hours and the case gets dismissed. I keep saying probation. Community service. It's just community service. He had to do volunteer work. He was like, yo, thank you so much for that. He paid an attorney $18,000 over 2 years. He met me. I told him one thing to do. Got his damn. He got his case drastically reduced to a damn. He went from facing jail time to another charge offense on his record to damn community service. I'll be damned.
My man. Right on. All right.
So, yeah.
We're going to close up now. we're gonna close that. We're gonna, we have on Sunday, on the Moroccan Post on Crumb TV, we have two guests from the Society, the Moorish Society. We have two guests, Cheyenne and Brother Elam. They'll be joining us on the Moroccan Post on Crumb TV at 6 p.m. Eastern Standard Time. I'll send out the I always send out the link to people who are my whose phone numbers I have, and those who are on my messenger. Well, we join us on Moroccan Post on Crumb TV. We'll be streaming live on Crumb TV, 6 p.m. Eastern Standard Time. All right, so this will be uploaded. Terrence, want to talk about the uploading when this will be available?
Absolutely. That's why I would like to end on time when we do these classes, because I do wake up extra early in the morning. And but I will work to get this uploaded on what's called Moroccan Post Media. We do have a Moroccan Post YouTube channel that we do not have access to. So we have Moroccan Post Media. And so that YouTube channel is not finished being built out yet. I do have standing now about 9 videos. So,
all right, brothers, I'm out of here. Peace and love, Brother Abdullah. So, brother,
all right,
I'm out of
peace.
here.
All right, peace. So I will work to get that uploaded tonight after we close out. So, but
Yeah,
Moroccan Post Media.
So share it when you go to the YouTube page, like it and subscribe and like the video, and also share it. It's like I said, there's other videos on there, but this will be uploaded. So share it as well as subscribe and like. All right. So I want to thank y'all. I've taken attendance. I'll be taking attendance every week, so we can have a record of those who come to the class. All right, thank you again. And so we'll see y'all next Wednesday. We've actually dealt with a lot of, Shem answered a lot of, I think maybe all of the questions. Not.
Actually, he probably did.
I think he did. I
And
think
look
look at the questions, and he didn't answer. He answered all the questions, in fact.
Do we have time for one more question?
No, we got 30 seconds.
Yeah.
Okay. Well, brother, you could.
So
Yeah.
no.
Hold on to that until next class.
Yeah, because we got 30 seconds. It's 10 o'clock now, so we're going to end. All right, peace, everyone. I see y'all on Sunday, Moroccan Post on TV, and see y'all next week. All right, peace.
Love.
Peace.
Peace and love.
Terrence, you saved it? Did you end the recording? Terrence.
Yeah.
Did you end the recording?
I'm doing that right now if I can see it. I don't even see it. But anyway.